Tune in for Series 5 of the Hip Talks, a podcast series of discussions on legal issues hosted by Hugel and Ip Solicitors, an independent boutique law firm in Hong Kong, providing bespoke legal services and exceptional client service to individuals, families, entrepreneurs and businesses, both locally and internationally. The forthcoming podcasts are the Barrister series. Over 6 episodes, the team sits down with preeminent Hong Kong barristers to discuss contentious issues related to civil litigation, employment, family, trusts and estates, as well as increasing awareness about the importance of the role of barristers in court proceedings and the relationship between solicitors and barristers when acting for clients. Hugel and It provides expert advice across a variety of dedicated practice areas, both contentious and non-contentious. An outstanding team of solicitors who have achieved exceptional results and recognition in the areas of dispute resolution, probate and trusts, family and matrimonial, corporate and commercial, and employment and immigration. Hugel and Ip applies modern thinking to legal services, uses technology in a contemporary office environment, and is fully committed to giving back to the community.
Hi, my name is Raphael Wong, and I'm pleased to be joined by Felix Li, a practicing barrister in Hong Kong. Hi, Felix.
Hello. Thank you for inviting me. I'm very happy to be here.
Yep. So today's talk is mostly about children. And before we go into that, perhaps you can tell us a little bit more of your background?
My background, okay, sure. I have been a barrister for almost 20 years now. I got my qualification in the UK, and then, but I didn't practice there. I came back to Hong Kong immediately, and I started practice around 2006. So it's been almost 20 years now. And since day one, I have had experience in a range of cases, as it is quite usual for junior barristers. But I have had family cases since day one, so I was quite lucky.
Yeah, I remember when I was still a trainee solicitor, I had a case with your mother, actually.
Did
where
you?
She was as a mediator, and we settled the case, actually. A very messy family case as well.
I see. I see.
Way back.
Yeah, it is not unusual for people in our profession to have family members, grandfathers, mothers, fathers and son, mothers and son, mothers and daughters, and then eventually some may even go on the bench. So you've had it's part of the tradition. I can say, yeah.
So is there any particular reason why barrister over solicitors?
For me?
Yeah, for you.
Yeah, there's a range of reasons. Number one, I don't think I can work so well repetitively in an office for long hours. So I have, since the beginning, thought I either become a barrister, which I know it's self-employed, and now that you've mentioned, I have family members who's also a barrister, so I know exactly what I was going to get, as opposed to going into a sort of office hour work. So at the beginning, it was either barrister or do something else.
Presumably that something else would be music.
Maybe, or something of my, other interests. Yeah. It's more suited to the character.
Right. So we all know that in the divorce settings or family disputes, we usually have to deal with 2 main areas. One is children, and then in the other one probably is money matters.
Yeah.
So between the two, do you have like a preference for yourself?
I like children cases. I always think money matters, it's easier to resolve by the parties. They should come to some sensible decisions. Whereas children matters, sometimes I can understand they are in deadlocks, especially modern days where both parents take active roles. They are fully entitled to think their way of thinking about what is best for the child trumps over the other one. And there's no solution. In their world, there's no solution. So they really come to you frustrated. Whereas money, in a certain way, I think it's like a commercial decision. And they know what they're playing at. So out of the two, I feel I can make myself more useful in the area of children.
Right. And we all know that supposedly in the ideal world, children matters and money matters are separate matters. But have you seen cases where the parties try to link the two matters together?
Of course, always. I suppose that's where we come in.
Exactly.
And it's not wrong for them. Well, first of all, when, divorce is like having a surgery. If you are lucky, you never need to experience that. So I respect clients in a way that they are going through a phase of life they've never come across before. They don't know what is right. And for laymen, when they talk about divorce, of course, they mix children and money matters. I'm sure you also, we have a lot of clients which think whoever gets the custody needs to maintain the child financially. Yeah, so I think that's why we need lawyers.
Correct.
And we need good solicitors.
Right. And for the purpose of this podcast, maybe we should briefly define, when we talk about children, who exactly are we talking about?
Sure. I think without going into any specific legal terms, I can say the existing legal system covers almost all kinds of situations. If I put it in another way, there aren't any loopholes, or there won't be a situation where a child in Hong Kong needs help, but the law doesn't cater for it.
I remember there are some odd and weird cases where, for example, the party is getting married and then later on there's a child, but years after it turns out that the child does not belong to that husband or the so-called father. What would the court do in such a situation then?
Well, again, without going into the legal terms of things, parties can be rest assured that the court has a duty to look after any children, right? However, when parties in a divorce setting, there are certain thresholds that they need to satisfy in order for the court to accept what we call the child being a child of the family. So, again, I don't want to be too legalistic about it, but in short, if you have treated the child as your own, you have lived together, you have basically lived a life of a family where the child and the parent treats each other as parent and child, nobody should be worried.
Okay, now we have defined basically, as you said, the children of the family being the subject matter. Then how about we talk about the role of the judicial system? Probably this is the listeners the most concerned with, what they can expect from the courts, from the lawyers, and how the courts would pretty much help them resolve their issues.
Sure. For me, and personally, I find this interesting too, because I always put myself into clients' shoes. It must take them a lot of courage to walk into a law firm and ask for execution of a divorce. Whereas I can only imagine they must have spent so much time before that, either researching on their own, or talking to friends, talking to professionals in a friendly manner. Yeah. And unfortunately for me, if I can make this analogy, it's almost like the surgeon. So when the patient comes to me, they're already pushed into the room and I'm about to perform the surgery. So I never get to see the first parts.
Mm-hmm. Well, that is, in fact, the key distinction between the role of a solicitor and a barrister.
Yeah. So in a way, I'm always intrigued how these people takes the courage and make their choices to come to you. And then, of course, you're asking me the role of the judicial system. Perhaps I'm now putting the question back to you, because I'm just thinking that would be one of the things that, as lawyers, be it solicitor or barrister, when you first see a client, you need to comfort them, as well as giving them the reality that now that you have decided to use the judicial system, and if the divorce, unfortunately, is contested, which means you need to fight, and then fight needs time. So,
and costly too.
Well, of course, but time is priceless. The time is usually when clients come to me, I would run them through. I would tell them, look, if you're going to dispute this, dispute that, which you may be right to dispute them, or you don't dispute, but the other side may want to dispute. It's going to take this amount of time. You may need to go to court how many times, and are there window of opportunities for you to settle at different stages? And usually, when I say usually, 99 out of 100, that timetable comes out to be longer than what they want. And if I'm in their shoes, I would be a little bit surprised too. Like, for example, if we have a divorce where the marriage itself is around 3 to 5 years, and if we tell them it takes the equal amount of time for you to go through the divorce, it doesn't make sense to them. So I don't know, is this the kind of judicial system you want to talk about, or you want to be, you want more exact?
I think what I wanted to ask mainly is, from the court's perspective, certainly they are not teaching what the parents should or should not do. After all, as you said, the divorce, say maximum 3 years, but the court's jurisdiction over children matters maybe until the children are 18. So the court process is going to end soon, relatively, compared to the 18 years of the children's life. So very, very often the courts, at least my personal experience is that the courts very much encourage the parties to come to a settlement themselves, because there's only so much the court can do.
Absolutely.
They can, of course, it's the role of the court to make a decision on behalf of the parents. But my experience is that if it is a decision made by the courts, then there's only winner and losers. So one party is bound to win, when the other side is bound to lose, or sometimes both of them just lose because neither of them get what they want. So at least my experience is that parties are often better off if they reach an agreement themselves. And it seems to me that this is where lawyers can add value to their clients. Very often, a lay person, they might not have received legal advice, and they will have to trouble the courts, and then the courts might spend extra time just to explain to them the position and what they should or should not do. You said it as a deputy judge. What was your experience in relation to this? I'm not talking about specific cases, obviously, but as your experience as a judge, what do you observe when you deal with people who has no lawyers?
Not easy, but before we get to that, you've raised some very, very core and I think very, very good points about the area of children within a divorce setting. First of all, settlement is always encouraged. Whether from the eyes of the court, I have served the judiciary a few times, and I can tell you for sure that it's nothing to do with workload. It's never the case. If lawyers come to court and think the judge walks out and want a settlement because the judge doesn't want to work, that is very wrong. In fact, it's one of the first principles, I think, that if possible, settlement is always good for parties in divorce, in family settings. Because after all, we all know it could be a marriage of 30, 40 years. And as much as lawyers give you all the attention, as much as the court gives you an appropriate amount of time to fight over whatever issues, how much time in reality can the court give you? A 10-day trial?
Mm-hmm.
But you're talking about a 40-year marriage. Of course, that jumps to another area which talks about how much the court will see or how little the court will see the conduct over a long marriage of 30, 40 years. But generally speaking, yes, settlement is always encouraged. That brings to the next question, whether the parties can always have the right type of lawyers. I'll come back to your question later about parties having no lawyers. I'll talk about that. But before that, because Raphael, you are in a very prestiged firm which specializes in areas including matrimonial. But we all know in the daily world there are all sorts of different types of lawyers. And there's no barrier to entry in the family court in the sense that you can get any types of lawyers representing their clients coming to the family court, but they don't have this settlement-minded thoughts or maybe lack of experience in this area. So that's the other problem. Or, well, I shouldn't say it is a problem. It's a reality. So the quality, the types of lawyers the court has to deal with, that's another thing as well.
Right.
Right? And it is important whether it is solicitors or barrister. For example, I can only speak for myself. Mm-hmm. There may be other types of barristers. There may be other, even in matrimonial practice, where we all have our different personalities. We all have our little subtle differences. I'm sure you can tell.
Yeah.
You can tell me more about that.
I understand that some barristers only focus on, say, for example, money matters, and they said they do not do children matters.
Yeah. Yeah, well, for myself, because I have slowly, I can't use the word specialized. I'm still learning every day.
Yeah, we all are.
But as my practice went on, I found there more and more matrimonial cases coming to me. So that it got to a point where there would often be clashes of diaries. It became not. I felt less comfortable doing the full range of civil, criminal, matrimonial. So at some point, I decided, okay, I'll cut down the other practices. Mm-hmm. I'll focus on matrimonial. Mm-hmm. So that's how I built up my practice in this area. And as I said, there are different kinds of barristers with different preferences or different takes to a case. But you all know me pretty well. We've worked together for a long time. I'm always settlement-minded, and I'm always very, very open about that. Mm-hmm. So in front of clients, in front of solicitors, solicitors that I've never met, even in court, they all know that I'm always up for a settlement. And that just, for me, is the right thing to do.
Right.
But then bringing that back to when it always takes two to tango. We all know that. If the other party, let's say they don't have a lawyer, or they have a lawyer which specializes in some other areas of law, you've never seen them in the family court, then you need to be extra careful.
Right. Yeah. So,
well, perhaps let me answer you also. When both of them are not represented, so that's the interesting experience I can only get by serving the judiciary. Right. I didn't come to think of it as much because we as lawyers, whenever we go to court, that means our client is represented.
Correct.
So at most, we get us versus the other side who is acting in person. But we've never been in situations where both of them are acting in person with no lawyers. Act in person, generally, it's a lawyer's term. It means neither party are legally represented. None of them have lawyers. So I had the great opportunity to experience that when I was serving the judiciary. So you get one day you walk out, the whole room is just full of no lawyers. So you have the husband acting for himself, you have the wife acting for herself. It's not necessarily all bad. In the sense that the parties can tell you more directly what they want, whether they know what they're doing, right? But I'm sure you can imagine, whereas when a lawyer comes, he or she will have a bunch of things they want to say, or he or she has already advised the client outside court that when I go in, when I see the judge, I'm going to say this, that, and that. I'm going to get A, B, and C for you. So it becomes more difficult if that A, B, and C is something not sensible. Whereas if both persons, they don't have lawyers, so in a sense, if the lawyer is not a good lawyer, so allow me to use the word contaminated, so they're not contaminated. They can tell the court exactly what they want. And you can't assume people who don't hire lawyers are unreasonable people. That's a wrong assumption. Some people come in very timid, very educated, very well-spoken, and make good choices. So it's a mixed experience. It's not necessarily bad.
Now, we also briefly talked about the so-called division of labor between barristers and solicitors. Usually when the client first come in, they will have to approach solicitors first, and then they instruct the barrister. So what do you think? So I'm sure you have worked with a lot of solicitors. From your perspective, how do the solicitors add to the value in trying to resolve the matters?
Wearing the hat of a barrister, of course, I am always very grateful for solicitors having filtered a lot of information. So usually when the client comes to me as the barrister, I know they've been taken care of by the solicitors already, in the sense that the solicitor would have elicit all the relevant information. So that makes my life a lot easier. I suppose the downside is, as a barrister in matrimonial context, I always prefer to come into the picture as early as possible. And of course, that I suppose everyone would say that too. Bring the case to me earlier.
Yes. It also makes sense because sometimes the case develops on a regular basis. And if you are in the picture earlier, then you stay on top of things. And otherwise, sometimes some details might be lost. And so even as a solicitors, right, we have contacts with the clients sometimes on a regular basis, daily basis, and sometimes on the weekend because children matters can be unpredictable. Things could have happened over the weekends, for example, like access time, pickup, drop off. There might be some difficulties. And those are the times where the client would come to the solicitors first, obviously. And
that's the time when I again and again think, okay, I've made the right choice. I didn't regret.
This is exactly what I wanted to say.
If I were to become a solicitor, I'm not so sure if I have the time and patience to deal with matrimonial clients. And that is why I'm not just saying this. I'm truly grateful for solicitors handling clients. I think I can perhaps say in family cases, I see myself as part of the team in a sense that traditionally, solicitors, of course, you handle clients. It's client-based, whereas traditionally there's the segregation because barristers are supposed to be more impartial. You should, so the judges can take your words. They know that you can build up the rapport between the bar and the bench, the bar table and the bench, etc. But in family cases, it's always teamwork. I always tell the junior barristers or sometimes my pupils, you cannot expect solicitors bring in clients and then you put up a barrister look and then you think, okay, I do ABC and D, E, F, G, H, I, J, K. That's not my part. That's wrong. It's teamwork. It's barrister needs to handle client as well during the times when we see clients. But we know every holiday, and it's very annoying because for you, or the peak season, so to speak, the Christmas holidays, all the important days, summertime, when you yourself would want private time. So you have all these people calling you during weekends, during Christmas Eve. Oh no, he's promised me 6 o'clock at the lobby. Now it's 6:15. What do? He now says the child has a low temperature, and he's throwing a temper, not coming down. So what do? Or at the beginning of divorce, you can have a client calling you 20 times a day. Should I change the lock? Should I change the lock? Or should I kick him out? Or should I leave? What if I leave, I can never come back to the house? So I appreciate all that.
Yeah, that's why we work so well. You've talked about what you've discussed just now it comes to my mind the so-called legal principle when deciding matters, because we said, in situation, for example, urgent decisions to be made by the courts, there's only one guiding principle, that is the best interest of the children.
Yeah.
And what intrigues me the most, according to the common law system or under the common law system, is that there's no definition of best interest. It seems to me that different judges, given the same or similar factual matrix, based on their background, their experience, they might come to a different outcome.
Well, but funny enough, it's only fair that big words like this, best interest of a child, if we look at it the other way, we cannot possibly have a list. As long as you can make that list from, 1 to 100, there's always the 101. And the thing with children cases, which is so different from any other cases in the world of litigation, is that, and I always tell this to people, if you think about however complex a criminal case, let's say there was a massive big fight and then someone ended up dead. However much scrutiny you can put into that situation, the incident, it happened maybe over, it could be as short as 1 minute, 2 minutes, let's say 5 minutes, or sometimes in sexual offenses, maybe over a period of time. But you're always still talking about scrutinizing a period of time in the past, and the court then gives a ruling. Same for civil cases, be it water leakage from upstairs or any type of civil cases you can name. Or in the commercial world, there are lots of commercial contracts, there's breach of contract, etc. You're always looking at something that happened in the past, and then both parties, of course, they collect evidence, and then the court will rule. But children is completely different, because we all know the child will grow. So the court's decision is not about in the past who was right and who was wrong. Neither was it's all about the best interest of the child in the past.
Right.
So you don't come to the family court complaining of a child being suffering under the care of, let's say, one parent, and then ask the court to make a ruling of that. Unless that's child abuse, that's different. So you will hear the family court always say, well, we're not magicians. We don't have the crystal ball. We can't tell you exactly what will pan out for your child. If the two of you are now going through a divorce and your child is only 3 years old, how can anyone predict what will happen until 18? Not even feng shui master. So for me, that's the interesting part, and that's partly why I like children cases so much, because it's lateral. You cannot look at it in a linear form, and there's no right or wrong in the sense that who did what in the past. And that brings, Raphael, back to your question. So best interest of the child. I think one way of looking at it, and hopefully the listeners can relate more to, is it's not really talking about the past. It is in a sense, because in the legal system, somehow judges still needs evidence. And when you talk about the word evidence, it has to mean something that has happened in the past and you're trying to say it will happen again. But, and it's a big but, when you talk about best interest of a child, in the true sense of the word, it has to be what the child is going through now and for the foreseeable future. It's never defined in such a way, and courts will never say, I'm now making a ruling or I'm writing up a judgment. Up till now the child is 6, I can only foresee reasonably up till maybe he's 9 or 10 or 12. You never see that. But the reality is, how can anyone predict a 6-year-old up till 18 or even beyond? Because the law allows, usually when we talk about interest, it can go up till the completion of full-time studies. So you're talking about 21, 22-year-olds. So as much as the court come to a decision over a child, when I say child, it means child arrangement, the court can only do its best to reasonably foresee a period of time, but without defining that.
Right. So from your perspective, after all, you have been in this area of practice for quite some time, do you see the court's interpretation, if I can call it, of best interest, a change, something that's changed over the course of the years?
Yes, definitely. In terms of culture, and I can only speak for my experience as a practicing barrister in Hong Kong. So in that sense, I can only speak on behalf of the culture as I understand it now in Hong Kong when it comes to the child care. I think the obvious point is, because nowadays men and women are more equal in every sense of that word. So it's normal for fathers to pick up childcare roles, where in a traditional, especially Chinese setting, we always have a saying, the man takes care of the external and the women takes care of the internal within a marriage or family. So that it's no longer accurate, because in modern society in Hong Kong, men and women take up almost equal roles. Really, really equal, in the sense that if you walk around the streets now, you can see fathers having tissues with his left hand, right hand, it's holding the milk bottle, or with carrying all these baby stuff. And you don't see that as abnormal. You just think, okay, this is a father performing his duties. And of course, then you see all the women in suits, working, finishing work, going back home and taking care of children. So in that sense, men and women are equally accepting each other as child carer. So of course, every family is different, and we all know that.
Yes.
But generally speaking, so that makes it more difficult compared to, historically speaking, compared to before. When parties go through a divorce, both parents had been hands-on, rightly so, and they cannot split the child.
Right. Yes. So you mentioned a great point, because my experience is that some perhaps more matured clients, they would come to me and ask, or under the assumption that, oh, since I'm the mother or since I'm the father, do I automatically get only can control or get only access rights? They are still operating under the assumption that, oh, if she is the main carer or if she is the mother, then she will automatically have custody of the child. That brings me to because recently we talked about the law change, right? We tried to change the children, at least the legal principle in relation to children matters. We want to get away from those legal terminology like custody, can control, and to some more neutral wording, say parental responsibilities.
Yeah.
So how do you think about this this idea of changing the legal system, or at least change legal principles?
I think it is a good idea to take away the labeling. As you have rightly pointed out, parents walk into the courtroom, and you can't blame them, the laymen, and they're going through probably one of the worst times in their lives. You can't blame them to think that I've invested time, resources, I've got good lawyers like yourself to fight, and of course you cost money, and then I want a result. And if I don't get that result, I'm not winning. So you're right in a sense that the courtroom does give automatically people a sense of winning and losing. Even to us.
Correct.
As much as we try to detach that, of course, when you get everything you wanted from the judge that day, you would brand that a good day. Whereas if you get shouted at, reasonably or unreasonably, then you perhaps after work, when you go for a drink with your friends, you tell them, I've had a bad day.
Yeah.
So it's only normal for people to have this winning-losing mentality. But again, that goes back to how special the area of children is.
Yes.
Because we're talking about a child, and it's not just the law, but the society accepts, and I think I can boldly say, not just Hong Kong, Asian countries, Western countries, I can't say globally, but the parts of the world that we are more familiar with, it's all running the same concepts. It's now child focus. So when the world accepts children these days are born and they are being nurtured in more sophisticated manners, then it is only right for the court to look at the child. So the court it's only doing what the parents and the rest of the world have been doing all over the years. It's child focus. So the court is also child focused. But the problem is the child never ever goes to court. This is something that laymen, they will know perhaps in the first conference when they come to you. But if they are general public listeners to this podcast, then a lot of them, they don't even know. They should know. Children never go to court, except in very special situations where the judge wants to meet the children. Right. But generally, when children don't go to court, and the court is solely focused on the children's best interest, so that's the difficult part. So in the eyes of the court, there's no winner or loser, because mother is only fighting what the mother thinks is right for the child, and equally the father is fighting for the same. And there should only be one winner, and that winner is never in the room. So that's that's something that needs time to digest for anyone.
Well, I can easily put myself into the client's shoes. I must say that before I have children of my own, my interpretation of best interest is quite different, frankly, because very often you have clients fighting for additional hour over the week, or maybe two best, and then they would just spend thousands, if not millions of dollars just to argue for that additional hour. But after having a children of my own, I will often ask myself, if I'm put into the client's shoes, if I only get to see my child 1 hour per week, I think I would go crazy as well. So, and I have to constantly remind myself that whenever I'm advising clients, it will have to be the best interest of the children, not necessarily myself. So my personal experience teaches me how to keep in mind that whenever I give advice, I need to think from the child's best interest point of view. But very often the client would think that they are making decisions based on the best interest of the child. But very often the court might not see it the same way. And this is how we would need to manage clients' expectation. And perhaps this is how we can help the courts to resolve the matters, because not only that we are acting for the clients, but we are also officers of the court. We have a duty to assist the courts in resolving the matters as well.
Well, yeah, one point you've raised, and it's very true, is that you get a lot of parents fighting for time slots. And again, you need to respect the parties in the positions that they are in. That's all they can do. That's what they think. That's all they can do. For example, you get a lot of, whether fathers or mothers, they would think they are entitled to half of whatever time that is left of the child. So, like you say, they would go very far to fight for that extra hour. They think it's unfair otherwise. But this is another problem where the court sees things differently. It's not the quantity, but the quality of time. So giving a parent, let's say 50%, okay, if you call that being fair. But however, one parent is left with the 50% of time where the child is in the middle of school week, whereas the other parent get the weekend times to play when the child is more relaxed, when the child has less pressure from homework. So do you call that fair? So, but however, the court cannot help parties by making an order that you must have quality access with the child. the court can give you, for example, a weekend, but what you do with it, it's entirely the parent's responsibility or your choice, right? So how often do we get parents fight and fight and fight, and eventually, they get a weekend, and what do? They take the child, sit at home, the parent does his or her own things, and then the child watches TV or iPad. And then when the child goes back to tell the other parent goes to the lawyer and say, look, I've spent so much time fighting for this or fighting against this. Now he got it. Look, it's just wasting the child's time. And then go back and fight another round.
Exactly.
So, Raphael, perhaps this brings to another big point where I think maybe I can only speak for myself, but I think in children cases, another special feature, and it's so different from any other types of litigation, is that the court can only step in and help parties for a particular period of time, meaning whatever issues that you have with your child post-divorce, it is ultimately still the parent. It's impossible for the court to become the parent of the child. And if that's what the parties want, then they are most irresponsible. From a practicing barrister's point of view, sometimes when I'm into a child case, sometimes I get that feeling too. Perhaps after a long conference with client, or maybe even in the middle of a trial, sometimes I do get that feeling. So why are these people shoving all these decision-makings, responsibilities to us, solicitors, barrister, judges? Why? Because you want to seek justice, but you're looking at a child's growth when nobody can tell you. Yes, there's a divorce, we all empathize that, but still, it should be the parents. So again, probably this then comes down to the division of labor between us, so barristers and solicitors, how we educate the client and support them in the right manner in telling them, look, we can give you guidances. The courts can give you a glimpse of guidance. It's like going to a fortune teller. The fortune teller then tells you, look, I can only tell you what will happen in this particular year, or maybe next year, but I can't possibly tell you further on. So it should be the same. I think it's the relationship or the communication between the legal team and the client in this respect that we should let the clients know it's your child. It's your and your divorced partner's child. You two need to deal with it in the end.
Exactly. So that's why I said it can be a vicious cycle if the parties operate off the mindset that they need to fight until their teeth. Then it often becomes a situation where they obviously very hostile. And the more hostile they become, the less they're able to co-parent the child. And the more issue down the road. So that's why, perhaps that is why the courts would often encourage the parties to reach a settlement between themselves, because this is just, they have to deal with it. They are parents for life, basically. The court may be able to resolve this imminent issue for you once or twice, but ultimately it's you who are the parents that have to look after the child. So ultimately the parents will have to work with each other, but not against each other. And going to courts probably doesn't help that much.
Well, yes, you've raised the word co-parenting. I think this is correct. This is trendy. This is the way to go. And there are social reasons behind it as well. Nowadays, parents, or compared to the traditional historic Chinese parents, where back in the days, the women don't work as much or they don't get educated as much. But these days, as we've just discussed, men and women are equal.
Yeah, and more families are having domestic helpers so that both parents can work.
So in that sense, neither of them can have any excuse for not learning how to continue to be parents when the marriage don't work. Of course, socially, that may be another topic for another day, where you have different people making the decision to divorce for different reasons now compared to before, where, or maybe I just give one or two examples to make my point clear. So traditionally, we face with the clients coming to you maybe after the children have grown up, or when the couple are in their 60s. But these days, we have a lot of relatively young couples getting divorced with children. Of course, socially, we all know the reasons, because now the men and women are equal. So for the mothers, they would often tell us that they still have choices, and they're able to raise the children by themselves. So the point in time when people get divorced has changed also. So that affects how the court deal with children, and that partially explains why the court is now faced with a lot of divorce cases with young children. Because socially, they now have the courage to do it, the young couples. And with these children left behind under a divorced family at a young age, so that is what calls for co-parenting, right? Whereas traditionally, if the children are more in their teenage, closer to 18 or even beyond 18, then arguably it's up to you to co-parent or not, because you're almost dealing with an adult child or an adult child. But nowadays, why we're getting more and more clients with very young kids, or kids of a various spectrum of ages, but relatively pre-teens, I think that is a valid point as well, and that calls for co-parenting. So if they don't learn how to be parents, but a divorced couple, then it's bad luck for their child, in a sense.
So indeed, co-parenting is something quite important, and equally important from my experience is that the parties need to learn how to explain things to the clients, explain things to the children. Sometimes I've been asked questions like, how should I explain to the child of our party's separation? How should I tell my child that the father still loves him? He might not have abandoned him. The fact that he doesn't want to see, he spends little time with you doesn't mean he doesn't like you. So I find it very beneficial for the clients to engage help from third parties as well, such as psychologists, for example, where they can learn how to speak with the child. And a very occurring theme in divorce cases is that one party might badmouth the other parties in front of the child. It's very damaging to the child, and quite frankly, it's sad to see these cases. And I'm sure you've dealt with a lot of alienation cases as well. These are often very difficult cases, and sometimes frustrating to a point that court order by itself might not be able to resolve the issue.
Yeah, this is no doubt a difficult area. You are absolutely correct that if it comes to a point where professional third-party help is clearly beneficial, then of course go get them. But there's always the counter-argument of trying to protect the child from seeing different professionals, especially whether or not they are really distressed or have problems themselves is an issue. So a lot of parties in such situations, they would brand or they would suspect the child to be suffering from some special issues.
And they would rush to bring the child to see the third party's expert and then to produce evidence in court.
And I've read many of these reports, and a lot of them will say either boldly or nicely that your child is actually okay, but he or she is just distressed over the parental conflict. So we're trying to avoid that situation, but there's no simple answer to it. The area of alienation in reality is difficult. I can only say from my experience that if something like this seems to be a theme in a divorce case, try tell the parties, first of all, not to involve other family members. It's already difficult just between the two of them. If you add on all these grandparents, you add on all these relatives, sometimes they live together and it's unavoidable. But try as much as they can. So we can only advise one client. Of course, we can't advise both. But we can only do our best to tell our own client, look, keep it between you and the other side, the other parent. Don't involve your other family members. And look at the situation first. Look at your child. Don't jump to these professional help yet. See what the problem is first. Right? But of course, for some cases, if the child is reacting, for example, physically, or the child loses sleep, or the child refuses to go to school. So there are all sorts of reactions in a child. Sometimes the child looks sad or distressed, but sometimes there are other more visible reactions from a child, for example, refuses to eat. So if it comes to those, of course, we need to protect the child as well. But the other point you raised is also right. So what if you have a very reasonable and good parent on one side and the other parent is acting so unreasonable? Yes, and he or she might be the culprit of alienation. Then so what? What do you want the court to do? A lot of clients will say, okay, punish him, punish her, send them to jail. There is such a procedure, right, Mr. Lawyer? Yes, there's such a procedure, but they've not committed murder. You're not going to send this person away forever. If you manage to get the court to act so robust, to send an unreasonable parent to prison because, let's say, she or he obstructs the child from seeing the other parent so badly with all these alienation, whatever term you want to call it, at most it may be a prison term of a few weeks, a few months. Then what happens? You think after that, coming out, that person no longer qualified to be your child's parent? No. He or she, that parent who's just gone to jail, will forever still be the parent.
Exactly.
And that is why the courts really doesn't like this part at all. The court will be most reluctant to send a parent to jail or any sort of punishment, because that punishment is not forever. After that punishment, if that parent who's just got punished want to seek revenge, so the game is forever going. So it's a difficult area indeed.
Indeed. Now, so far we've talked about divorce or children matters in general. I wanted to highlight a few things that are not necessarily unique, but more relatively more unique in Hong Kong compared with other jurisdictions when it comes to children matters. Now we talked about how domestic helpers is very usual in Hong Kong.
Yes.
And how often do you see domestic helpers come into play or being, let's say, weaponized, for example, by the parties in the children matters, in resolving children matters?
The parties will be keen to involve domestic helpers as part of the ammunition presented to the lawyers. So in that sense, parties will always come to you or come to me and say, is this useful? Is this useful? I've got the domestic helper on our side, or the domestic helper has evidence.
Or witnessed something.
Or witnessed something. So that's one area, namely to use the domestic helper as an eyewitness, or maybe use because of the text messages that she has with the other parent. The other aspect usually would be for a party to say, look, he's fighting care and control, but in effect, it's just a domestic helper doing all the duties. The father or the mother actually needs to go to work, or they have their own affairs. They don't really spend time with the child. It's the domestic helper. So that's the other aspect. Generally speaking, the Hong Kong courts, of course, they know the reality of many parents relying, especially working parents, relying on domestic helper, and this is generally accepted. So I've had clients coming up to me and ask, so can I limit the other parent whenever he or she spends time with the child? He or she has to be present. And the client thinks this is basic, because I can't remember it was a he or she, but that parent doesn't need to work. So all the time that parent gets with the child, he or she can spend really personally, whereas the other one has to work. So I said to him, look, it doesn't work like this. You can't limit. Then of course, then that client didn't understand. Said, well, the access is for the parent. You're asking the court to give him access between the domestic helper and the child. Well, that's the best the situation can be. So to answer your question, if I don't know, compared to maybe some Western countries where this domestic helper culture is less developed or not preferred, this is one thing that the Hong Kong courts will generally accept. Working parents rely on domestic helper and childcare. This is not abnormal.
And we often see cases where the party will simply fight for the custody of the domestic helper, or the win over the contract of that domestic helper, so that they will enhance the chance of getting the king control of the children.
Well, that's a matter of evidence, because as we all know, the domestic helper, if she's sided with one side, then whatever she says, how much can the court really take into account? Or, like you say, the contract is signed between, and it always is, one parent and the helper, then so there's an element of self-serving in there, in that even if you present this person in court, even if she does well under cross-examination, how much weight can the court really put on a domestic helper? And after all, it is not the domestic helper; it's a domestic helper. We, generally speaking, we all know it's always subject to change.
Indeed. Well, this topic can be quite broad because, after all, apart from domestic helpers, you can also have grandparents helping to look after the kids. So this just goes on and on. But it just simply highlights that children matters sometimes, although we try to limit it between the husband and wife. Unfortunately, some third parties' interests might be involved. And this is just, I guess, just part of life. Now, apart from domestic helper, I also wanted to discuss with you, which I personally have difficulty with, is the ECA, extracurricular activities. In Hong Kong, kids simply are subject to countless ECAs. We all know that. After school, they will have ECAs. And I have seen judges where they commented that, hey, the parents' time over the kids should trump ECA. But obviously, we need to strike a balance. We need to have some degree of ECAs. And at the same time, we need to look after the child's the ability to spend time with the parents. Perhaps as a judge, how do you find this exercise? Is it difficult for you to gauge or how much time we should give the child to have ECAs and allocate the rest of the time to the parents having access?
Well, first of all, every family is different. How long is a piece of string? We can't say there is a right number of ECAs. It all depends. Each family is different, and it's also dependent on the type of education, schooling that they've committed the children to. But I think generally I can add to that is, if the parties are already going through a divorce, which means the time spent with a child has now been split, when before, as a family, the father and the mother can spend time together with the child when the child is free. And Raphael, when you talk about ECA, we are talking about children, generally speaking, from primary school onwards. So the parents need to understand that being child-focused, and when the court look at the interests of the child, there's only certain amount of free time in a child's routine since primary education. Assuming it is full-time, which means a normal school day, which would be, let's say, from 8 to 3 in the afternoon, and then plus all these ECAs, homeworks, need to eat, need to wash up, need to sleep. There's really not much time in terms of the child, and the child needs to relax also. So even if for families which are not going through divorce, they are also facing the same problem with spending quality time with their child because the child is made so busy. And I'm not going to comment whether that's right or wrong. That's a cultural thing. But you've raised the topic of ECA. So on the assumption that children do go to ECA and do go to full-time school, full-day school, then if you look at it from a child's point of view, there's really not so much time left, perhaps the weekends. So the parents in a divorce setting, they need to appreciate the fact that they are now splitting the already limited free time of the child into 2 slots because they're no longer able to see the child and spend time together. So seen from that light, they shouldn't argue because there's only so much time. If you really care about the child and want the child to have, of course you want to see them and you want the child to continue to love you. That we all understand. But from the point of view of ECA, if it got to a point where a parent say, look, you can't even see the child over the weekend because I have lined up ECAs from Saturday 9 a.m. till 6 p.m. If you really want, I can give you those times, but you have to take the child to do this and then that, and then you can travel with the child. You can talk to the child in between. You can go for fast food, have a McDonald's before the next class. If it gets to that, my personal view is, look, if we take a million steps back and treat seeing the non-residing parent, or I don't like the labeling, Raphael, you know what I mean, the access parent or whatever you call it now, but in future I hope it's just called the parent which is not normally residing with the child. If we take a million steps back and think meeting the other parent is an ECA, that ECA must trump over all other ECA. Nobody in their right mind would accept the child needs to go play football, needs to go taekwondo, needs to play the violin over seeing the other parent. Mm-hmm. That's crazy to me.
I totally agree with you. And my experience is that this is unfortunately a very common theme where during the litigation, one parties would just jam-pack the child's diary with non-stop ECAs. And as you just explained or described, the party would request that the other parties do take the child to attend to all these ECAs and assume that he or she can spend quality time with the child even after the tiring ECAs. So it's just unfortunate that this is one of the recurring themes that we see often.
Well, look at it the other way. If you look at adults now, look at ourselves. Of all the things that you tried to learn during your childhood, be it taekwondo, be it all the sports, all the music, all the other things, how many of those have you managed to continue up to today? Well, maybe some for you, but generally not a lot. And for a lot of people, none. Indeed. So if you look at it that way, but do you still talk to your parents? Of course you do. Yeah. So it's a no-brainer. Cannot compare ECA with seeing the other parent. It's the wrong starting point.
Indeed. Yeah. Indeed. Now, another thing that I want to explore is, which is probably more unique to Hong Kong, is that space are limited. And very often, families would live in a very confined space, and they have limited resources to find alternative accommodations. Would from your perspective, does it promote more arguments between like a divorcing spouse? And if so, how would that affect children who might have unfortunately witness or hear the parties' arguments, sometimes physical, sometimes police might be involved?
Yes, but that is unavoidable. It's a fact that Hong Kong has limited living space. That's why the houses are skyrocketing. That's why we're now known to be one of, if not the most expensive city to live in. Mm-hmm. So this is a social problem. When argument arises within those four walls, yes, I think you're absolutely correct, whether it is divorce or not. A lot of parties, they don't go through divorce, but they argue every other night. Then the child witnesses. That's equally bad. But if putting it back into divorce context, my only comment would be, if the parties have decided to get a divorce, then they should be responsible enough to make the first move, and acknowledging the most important move is to be physically apart. Well, I don't want to go into the law, but generally speaking, if one party wants to get a divorce, eventually he or she will get it.
Yeah.
however much the other party wants to contest. So, and a lot of times, even at the very beginning, only one of them want to get a divorce. After a few months, it would become a situation where the other party would also want to get a divorce because of the things the other one has done to him or her. So my only comment would be, once that decision is made, and Raphael, we have a lot of clients coming to us, we find them still living in the same roof.
Yes.
And it could be for ridiculous period of time. And some of them are even more ridiculous when you find out they have the resources to move out. So I've had cases when they are certainly not confined to small places. They have the financial resources. They just don't move out.
For tactical reasons, obviously.
For whatever reasons. And it's irresponsible. So I can't resolve the space problem for anybody, but if anything, I would say for people who've decided to get a divorce, you must have a plan to be physically separated with the other party when there's children involved. It's never good for them.
Okay. Now, Hong Kong being an international city, right, and it's very easy for one parent to take the child to leave Hong Kong. And we've done cases as well where we need to help a party to, say, return the child from overseas to Hong Kong or or prevent the child from leaving Hong Kong. What's your take on this? Like, what is the court's role in this respect, and how can a lawyer help the client in protecting the child?
My take is, whether we like it or not, this will be a popular topic, and there will only be more and more cases of such nature. Namely, we are talking about people moving in and out of Hong Kong. I'm not necessarily using the word relocation in the sense that in the Chinese context, we're talking about moving to another place and never coming back again. I think this day and age, we talk about global citizens. People can make choices at different phases of time, living at some places, but we all know the mobility is very advanced these days. Everybody is just one plane ticket apart physically. And of course, we have all these electronic devices to keep in touch instantaneously. So the world has evolved as such. It makes traveling much easier, and it makes this kind of decision to go somewhere for a period of time more and more popular. So seen from that, then we get cases where, for example, a family decides to go to a new country together, and then somehow it doesn't work out as they thought, and that led to the relationship also not working out. Then ended up one party coming back to Hong Kong with or without the child. Then the other party would shout and say, "Where's my child? Why have you taken? Can I call this an abduction?" So that's one type of cases. The other type is simply families in Hong Kong. Every day, I'm sure many of them are contemplating the possibility of moving out.
Yes.
Again, I try to avoid the word relocation. So trying out different places. And maybe that leads to a divorce. Or sometimes it's the other way around. When the relationship don't work, when parties accept this is the end of their relationship, there needs to be a divorce, then they react by moving to another country.
Yes.
For example, if they have relatives in another country, or they want to start anew, or they've met a new partner elsewhere. So we get all these types of different reasons, and all legitimate and sensible. It's all understandable. So what I'm trying to say is that there's no malice in these type of applications to courts. In that, usually 9 out of 10, it's driven by genuine intent.
Yes.
But again, then the problem is you can't split the child physically into two. So it's always a problem with these kind of cases when you talk about the child arrangement.
So you try to avoid the word relocation, but unfortunately I have to bring you back in.
All right.
Because I've heard that I heard that relocations is probably one of the hardest decision a judge will have to make, simply because the implication that it will have on the child. As you said, if one party remains in Hong Kong and the other parties decide to take the child overseas for whatever reason, then they will be split apart for sure. And how to balance the the child's time with one parent and the other would be quite tricky and very often a factual exercise. Do you agree? Do you agree that relocations is probably a very, if not the most difficult question a judge can
well, I can't speak on behalf of judges. I'm fortunate enough myself, both as a barrister and I've had opportunity to help as a judge. But mostly throughout my experience as a barrister, I've been fortunate enough to be involved in quite a number of relocation cases. I suppose if you look at the end results, you could say it is, in my experience, one of the most difficult area because it ended up fighting. It ended up having full judgment published on this, whereas a lot of my cases are settled, and I take pride in that. So sometimes I do realize that too. How come out of the cases that I fight, the ones usually ended up having a judgment and having to trouble the courts to go through a full trial, a lot of them are relocation. And that speaks for itself. So the one party wants to go to another country, the other party doesn't. That's enough. And there's not that much room to have a complete settlement. So usually when I'm faced with these kind of cases, I still encourage the parties to at least narrow down the issues and realistically looking at that the country, the physical distance, because nowadays it could be as far as the other side of the world, or it could be as close as just across the border. So we get all types of relocation cases, and if it is physically closer, there are other possibilities. It's not as dramatic as the word may seem. And the issue of relocation usually links also with the issue of custody.
Yes.
Where some people might think, well, it's obvious when I'm allowed to take the child to the other half of the world, hours away from you, then of course, then the custody should follow. Then there are people who counter-argue that is exactly because you're taking the child away from me and I already lost that kind of daily control or information of what my child is doing, then we should have joint custody. So these are academic discussions, but generally speaking, I stick to my word. Even with relocation cases, parties still try to settle. Even if realistically, the chances of a complete settlement is very slim, there are always points that you can agree to narrow the scope of argument. And that would be beneficial to the parties because, Raphael, you and I both know how busy the family court's diary is. If you tell the court, I'm going to argue this, and that, A to Z, are you asking the court for a 10-day trial? If you insist, sure, wait 2 years.
Yeah.
Right? Then if you manage to narrow the scope, okay, we still need to fight it because the issue of relocation itself it cannot be resolved. But still, there are many small points inside. You can still come to not necessarily an agreement, but you can make the court's life a bit easier to say, look, if the child is allowed to go to another country, I would accept this, and that. But I still fight for the child remaining in Hong Kong. Yes. Whereas the other side can equally do the same. If the child remains in Hong Kong, I would then accept this, and that. But I still fight for the child leaving with me to another country. So that is beneficial to the parties themselves because then there's a better chance that they get the determination, the trial dates, and eventually the result earlier.
You also talk about a good point that relocations, not only that it is a very difficult thing from the court's perspective or from the lawyer's perspective, it's also very time sensitive. Sometimes the parties might need to take out the relocation application very quickly, but simply the court doesn't have time to accommodate, and it takes a very long time for the courts to come up with a decision. And not only that, it takes time, but it's also very expensive, or it could be very expensive because you need to supply the courts with a lot of information. There are a lot of groundworks to be done. And this brings to my next point, which is cost order in general in children matters, because I think from a lot of parties' perspective, this is quite important. Unlike normal litigation where if you win, if I can call it that way, or if you succeed in your request, then you might be able to recover some cost. But a very unique feature on children matters is that you usually do not get cost because the court's perspective is that both parties are trying to act in, again, the best interest of the child. So the court is unlikely to penalize the party by way of cost. And how do you what's your view of this idea of no orders to cost on children matters, and how does it affect, for example, when you're giving legal advice to clients?
I think it is correct. I think it is up to us as lawyers to explain to the clients, perhaps piggybacking on what I said earlier on, we need to tell clients that fighting children cases are so unique in the legal system that it calls for special treatments, almost loosely use that word. And it's really for us lawyers to tell the clients up front that, look, if you want to fight children matters, you're not fighting for yourself. You're fighting for the child. And therefore, don't expect the winning-losing scenario and don't expect legal costs being recovered. But then assure them, of course, that cuts both ways. You're also not expected to be paying the other side's legal cost, even if eventually the court rules more in favor of what the other side is proposing.
Right.
So that gives, and I think the principle must be correct because that gives the comfort zone for parent to genuinely fight for what he or she thinks is best for the child. And of course, they're not in agreement. They're going through a divorce. And this day and age, there are a lot of relationship breakdown actually coming down to the different take on how to rear a child and how to raise a child. So it's only normal that they are in polarized positions. But I'm quite sure currently this no order as to cost principle as a starting point, one of the big rationale behind is to provide that comfort zone for the parent insofar as whatever you propose is sound and reasonable.
Yes. We have covered quite a number of topics today, and Children Matters is so broad that obviously we can't just cover every single topic in just this podcast. There are other areas such as guardianship matters or parent, the cat void one, which we call essentially the child making a claim against the estate. And you have this whole idea of whether this children matter is a social issue versus a legal issue and all these matters. So we just have to leave these things to another podcast.
Sure, it's been a pleasure talking to you.
Thank you very much for coming.
Thank you.
Tune in and listen to more episodes of the Hip Talks podcast by checking the Insights section at www.hugelandip.com and the dedicated channels on Apple Podcasts, Spotify, Google Podcast, and Stitcher. They are also available on Hugel and Ip's YouTube channel. You can send comments and feedback to the email address hello@hugelandip.com. Please share the Hip Talks with friends, family, and business associates. This podcast is for informational purposes only. Its contents do not constitute legal or professional advice.